Great. Good morning. My name is Katrina L. Salazar, CPA, and I am the chair of the California Board of Accountancy's consideration of the CPA Experience Requirement Task Force, which we'll also be referring to as Cert throughout this meeting. Before we convene this meeting, please be advised that we are conducting this consistent with the provisions of Governor Gavin Newsom's Executive Order N-122. Members of the public that are interested in participating in the meeting must join the WebEx meeting. Informations and instructions on how to join are posted on the California Board of Accountancy website. All lines right now are currently muted. When we come to parts of the agenda where we'll ask for public comment, I will ask our meeting moderator to provide instructions and open up the public comment feature. We will allow up to 5 minutes for each individual to provide comments. But before we begin, and we welcome our members, a few virtual meeting reminders for our task force members. First, if you wish to speak, please use the raise hand feature and wait to be called upon. I will do my best to watch for those hand raises. Second, please speak directly into the microphone on the device you're using and keep your microphone muted when you're not speaking. And lastly, please turn on your camera and keep it on during the meeting. I would like to thank the Board of Accountancy staff as well as Solid for their assistance in facilitating this virtual meeting. It is important to remind everyone that the Board of Accountancy's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the promotion of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. With that introduction, I'd like to move on the agenda, and we will begin with agenda item number 1, which is the introduction of our CERT members at this inaugural meeting. I'd like to start by thanking President Savoy for appointing the members that will be serving on this task force. I'll start with my own introduction, and then I will go ahead and call on each committee member to introduce themselves and briefly tell us about their background. As I mentioned, my name is Katrina Salazar. I am on the California Board of Accountancy and am a licensed member with a CPA license. I have been on the Board of Accountancy since late 2012 and have served various functions throughout the board, including past presidency. Of note, I was also a participant in the 2015 task force that was considering experience requirements previously in the last iteration. I have volunteered for the American Institute of CPAs on committees, as well as with NASBA on committees, and as well as being a board member on NASBA since, I believe, 2018. I would mention that my industry experience includes both public accountancy as well as industry, and I'm looking forward to having this conversation with our task force and continuing it with the Board of Accountancy. So with that, thank you for allowing me to introduce myself. And I would like to next call for introductions Mr. Mark Silverman, who is a Board of Accountancy public member and will also be our vice chair of the CERT committee. Mr. Silverman, would you please take a moment to introduce yourself? Mr. Silverman, we can't hear you.
My apologies, Katrina. Thanks for the introduction. As Katrina noted, I'm a public member. I'm a lawyer by training, but I don't practice. I've been in various businesses for the last 35 years, primarily early stage and startups. And I've been on the CBA for 8 years and have served in various capacities on the CBA. And I'm pleased to be here today.
Thank you so much, Mr. Silverman. Next, we have Nancy Corrigan, who is a California Board of Accountancy licensed member. Ms. Corrigan, would you please take a moment and introduce yourself?
Yes, thank you, Katrina. I'm Nancy Corrigan. I'm a CPA licensed in California, Arizona, and Washington. My over 35 years of practice has solely been in public accounting with firms that ranged primarily from 15 to 70. Merged my firm into a large regional firm in 2016, and then I retired out from that. Not that I'm retired, but I'm self-employed now since then and working hard. And so my experience is primarily accounting, auditing, quality control over financial reporting, and then a general tax knowledge that one obtains working in a small firm. I've served on all three of the California Board of Accountancy's advisory committees, Qualifications Committee, Peer Review Oversight Committee, and Enforcement Advisory Committee. So all areas of what the CBA does and what our staff do for us. I was appointed by the governor in 2018 to the board. In 2019, I served as Secretary Treasurer. 2020 and 21, I was its president, and so I am now its immediate past president. I too have volunteered on AICPA committees and more recently with NASBA, and am the Pacific Regional Director, so serving on that board. I chair the Computer-Based Testing Administration Committee, which is very excited, giving the CPA evolution process. In advisory capacity, I help nonprofits in connection with their year-end audits and their financial reporting, and I'm happy to be here. Thank you.
Thank you for telling us a little bit about yourself. Next, we have Carrie and Farrell Hines, who is a Board of Accountancy public member. Ms. Hines, would you please tell us a little bit about yourself?
Sure, thank you again. I am a public member appointed by the governor in 2016. I've served on several committees on the Board of Accountancy, including the Legislative Committee, the Committee on Professional Conduct, and the Qualifications Committee. I'm an attorney by practice. I had practiced in areas of public interest law for several years, mostly representing pro-per clients or indigent clients in areas of family law. I currently serve as the Director of Government Relations for a social services agency, and just glad to bring my experience with public policy and governance matters to this body. Thank you.
Thank you for that information. Next, we have Rich Simidian, CPA, who is serving on Cert as a member of the accounting profession. Mr. Simidian, would you please take a moment and introduce yourselves to us?
Thank you, Katrina. Yes, my name is Rich Simidian. Well, for about 33 years, I served with a large public accounting firm. So most of my career has been in public accounting. I was an audit partner at Grant Thornton and served in a variety of different roles, but my client base, primarily mid-sized, privately held and publicly traded companies as well, but also took on some other roles when it came to human resources and practice quality and so forth. I did retire from Grant Thornton in 2019. Since then, among other things, I worked with local CPA firms here in Southern California on practice quality issues, responding to PCOB comments and things of that nature. And when I'm not doing that, as you can probably tell, I teach a course here and there. So I was teaching this morning, so I apologize for my late arrival in there. So, and I have worked with the State Society of CPAs. I was a past chair there back in 2013 and 14, and continue in a staff role with them on a consulting basis in areas of peer review.
Fantastic, thank you. You were right on time for the meeting start, so I appreciate your teaching as well as being here. It sounds like a busy day. Next, we have Mr. David Centini, PhD and CPA, who's serving on Cert as a member of academia. Mr. Centini, would you please take a moment and introduce yourself? So we're not getting audio. Can you check that?
There, it should be working now. Is that right? Thank you. Good morning, Katrina and everyone. My name is David Centini. I'm an academic and a CPA, and I've been teaching for about 40 years now, and I'm retired from back east. And my wife and I literally jumped in the car and ran away to California when I got a job at Cal State San Bernardino. They were kind enough to take me in. So I'm retired, but wanting to stay active. And I'm very pleased to meet you all and look forward to working with you. I know a number of the board members and staff, mainly through student events, and have worked with Kathy Johnson, and I remember Rich's name from somewhere years ago. We were involved in events together. So at any rate, I'm pleased to meet you in a little different capacity than with just students, and I'm very happy to be here. So thank you for asking me.
Well, welcome. Thank you for that introduction. We have Mr. John Cpa serving as a CERT representing consumers. So, Mr. Cpa, would you please introduce yourself to the group?
Yes. Hi. Good morning, Katrina and task force members. Great to be here. My name is John Cpa. I am, yes, I am the consumer member. I am really pleased to be here. I am serving as one of the roles I play is actually as the California State Director of the National Federation of Independent Business. We are the nation's and the state's leading and largest organization representing only privately held small business owners. And I've been doing that for about 15 years. I've been in and out of the Capitol. I had the pleasure of working with a few governors in a previous life when my hair was brown. And I also have had the pleasure of serving on executive staff with the California Restaurant Association, which also represents a lot of small businesses, a lot of job creators. Really appreciate the opportunity to be here as a consumer. Unlike most of you, I am not a CPA, but I play one on TV. As small businesses are really one of the primary users of CPA services, particularly I know attest services, but there's such an important consumer interest to ensuring that CPAs are qualified, competent, and also that there's sufficient CPAs in the marketplace. So really proud to be here, honored to be here, and looking forward to getting to know and working with all of you for some good things. So thank you again.
Thank you, Mr. Cpa, and sorry about the pronunciation of your name, but thank you so much, and it's great. I think we've got a nicely rounded panel, so I think Mr. Savoy did a nice job. But we are not yet done. We still have more stakeholders to introduce, and so next we have Dustin Cpa, who is serving on our CERT committee representing the National Association of State Boards of Accountancy. Mr. Dustin, would you please tell us a little bit about yourself?
Good morning, Katrina. Pleasure to be here today. As Katrina mentioned, I'm Vice President of State Board Relations at NASBA, where I really am responsible for outreach to the boards of accountancy throughout the country. And pre-COVID, tried to visit at least 15 to 18 of them each year. Also in my role at NASBA, I am liaison to 6 various committees like Education, Ethics, Peer Review, Oversight Committee, and several others. I'm a CPA licensed in both New York and Tennessee. Prior to serving at NASBA, I was the Executive Secretary of the New York State Board for Public Accountancy for 13 years. And prior to that, I worked for the Office of the Attorney General in New York as the Internal Audit Officer and Chief Accountant, and spent 12 years in public accounting. So thank you again, Katrina and Chair Savoy, for my appointment to this task force.
Thank you, Mr. Dustin, for that. And last but not least, we have Kathy A. Johnson, CPA, who is serving on our CERT committee as a licensee with general accounting experience. I do want to point out, just to make sure that we don't miss it, that Ms. Johnson also serves on the Board of Accountancy's Enforcement Advisory Committee and is currently the chair of that EAC committee. So, Ms. Johnson, hopefully I didn't take too much away from your introduction, but I would love to have you introduce yourself. Thank you.
Yes, thank you, Katrina. No, you didn't take too much away. Just a slight correction. I'm the vice chair of that committee. Didn't want to take anything from our chair, Doug Aguilera. Thank you. Okay, so yes, I have a variety of experiences in accounting. I am a CPA, and I hold a license in Texas as well as California. I am also an adjunct professor, and I teach both graduate and undergraduate courses at a variety of universities, and spent most of my career in business and industry, in the newspaper industry where I came up, and then over the last 10 years, I've been working in forensic accounting. I am a past chair of Cal Society of CPAs and a member of the AICPA's Council, and just really excited to be here and be involved in this discussion. Thank you, everyone.
Thank you, Ms. Johnson. Appreciate the correction for my misspeak. So with that, we do have a quorum. We have all 9 committee members present. And I would like to ask if there are any member comments on our first agenda item 1. So if so, this is a great way to test out the hand raise feature. If you will select that, I will go ahead and call upon folks individually. And seeing no hands raised, which is not unexpected, I will just say as we go through the agenda, if you raise a hand, but you are not called upon, feel free to give me a motion or a wave as well. I want to make sure that we're respecting everyone's contributions. So with that, no member comments, we will move along to, I believe we may have members of the public present. And so I would like to ask our moderator to confirm that. And then please open for public comment on agenda item number 1.
Thank you, Madam Chair. I am opening up the question and answer panel. We do have 8 members of the public in attendance. So if any of them would like to comment on agenda item 1, please type comment using the field in the lower right-hand corner of the screen and submit it to all panelists. Or you may simply raise your hand. We will give you a moment and we are displaying instructions for your reference. All right, this is the moderator. At this time, I see no requests for public comment. Shall I close the Q&A panel?
Please do. Thank you, moderator.
You're welcome. You're welcome.
So moving on to agenda item number 2, the discussion regarding the Board of Accountancy adopted objective for the CPA Experience Requirements Taskforce, or Cert. So the purpose of this item is to provide members an overview of this committee's objective, which was adopted at our November 2021 meeting. The Board of Accountancy directed Cert to use the following question as a guide to evaluate the experience requirements for CPA licensure within the state of California. And that question is the present attest experience requirement sufficient and necessary to support the CBA mission to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with professional standards? So to provide members and stakeholders and viewers context for evaluating this question, I'd like to highlight 2 points. So first, I'd like to note that in California, attest services are defined as an audit, a review of financial statements, or an examination of prospective information, financial information. So what that means is attest services do not include the issuance of compiled financial statements. And it's worth pointing out that this is different than what other states define as attest services, and that might be of interest to stakeholders that might be following the discussion. Second, our Cert committee is looking at the necessity and sufficiency of the present attest requirement. Cert could conclude that the attest experience is no longer necessary, or that the attest requirement is necessary and sufficient as is, or that the attest requirement is necessary but modifications could be made. So an example of that might be an adjustment to the required areas or the required hours, or maybe to the areas of practice where the applicants must demonstrate completion and understanding. Depending on how the Cert committee evaluates the question at hand, it could necessitate some of the following to occur. And that would include possibly developing a method to eliminate the attest experience requirement. including what backstops would be needed to put in place to offset the elimination of this attest experience requirement. So for example, that could be an attest accounting firm licensure registration process. Also, it could involve providing recommendations to, well, it will require the committee to provide recommendations to the board staff on how, and the CBA itself, on how to address policy issues that have been raised by staff related to our current processes. And these are outlined at the November 2021 meeting. They are also noted in our materials at agenda item 6, and we would need to address those as well as any additional policy issues that arise during these discussions that could be identified by the Board of Accountancy, our Cert committee, or staff. Lastly, the Board of Accountancy directed this Cert committee to use the following questions in its decision-making process. First, what's the problem the CBA is attempting to solve? 2, who will be impacted and how will they be impacted by any changes? And 3, how will the final outcome further the Board of Accountancy's primary mandate of consumer protection? This overview doesn't require any action by the committee. However, at this time, if there are any member comments about this introduction or overview, I'd like to call on members to use the hand raise feature. And pausing a beat, I don't see any member comments at this point, so thank you very much. And now it's time to open up for comments from the public. You'll notice we'll do this after each agenda item. So moderator, could you please open for public comment on agenda item number 2?
Thank you, Madam Chair. I've opened up the Q&A panel, and if any member of the public would like to comment on agenda item 2, please type comment using the field in the lower right-hand corner of your screen, or you may simply raise your hand. We will give you a moment. All right, this is the moderator. I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please. And thank you, moderator, for your assistance. So now we move on to agenda item number 3, which is public comments for items that are not on the agenda. So if I could ask the moderator to open for comments, any members of the public that would like to make a comment on items that have not been included in our agenda, you're welcome to do so now.
All right, this is a moderator and the Q&A panel is available. If anyone has not seen it, you may click on the question mark within the square at the bottom of your screen. Simply type comment using the field at the lower right-hand corner of your screen and submit it to all panelists, or you may raise your hand. We'll give you a moment. All right, this is the moderator. I see no requests for comment. Shall I close the Q&A panel?
Yes, please close the panel.
It's closed.
All right, well, thank you, moderator. So with that, we move on to agenda item number 4, which is our overview of task force related resource materials. And I am pleased to turn this over to someone else to speak. So I'd like to invite Michael Lieberman to begin that presentation.
Thank you, Chair Salazar. Item 4 provides the task force with resource materials related to the experience requirement for California CPA licensure. I want to provide an overview of the materials, starting with Appendix 1 in the attachment. Appendix 1, starting on page 3, includes relevant business and professions codes and sections of the California Code of Regulations. These statutes and regulations specifically relate to the experience requirements for CPA licensure in California. Appendix 2, starting on page 19, includes a copy of the 5 certificates of experience forms. Applicants must submit one of the certificates of experience to the CBA to verify their general accounting or attest experience. Please note that the CBA approved the initiation of a rulemaking process at its March 24-25 meeting. If enacted, these regulatory changes would remove the requirement for a second supervisor's signature on the certificates of experience forms and consolidate 4 forms into 2 forms, one for general experience and one for test experience. Of this committee, it is important to note that the rulemaking process does not propose any changes to the experience requirement itself. Appendix 3, starting on page 40, contains a chart with a breakdown of the CPA licenses issued over the last 10 years, with general accounting versus a test experience. Over the last 10 years, approximately 28% of the licenses issued by the CBA have had the authority to sign reports on test engagements. Appendix 4, starting on page 42, provides a link to the information on CPA evolution, the joint effort between NASBA and AICPA in recognizing the rapidly changing skills and competencies the practice of accounting requires today and in the future. The uniform CPA examination will be updated based on the CPA evolution model and will launch in 2024. Each candidate must choose a discipline section in which to demonstrate greater skills and knowledge. The disciplines are business analysis and reporting, information systems and controls, tax compliance and planning. Appendix 5, starting on page 44, outlines the jurisdictions with experience requirements beyond what the Uniform Accountancy Act and model rules recommend. I would like to thank NASBA for providing this data. As shown in this appendix, there are 10 jurisdictions that either have specific attest experience requirements or require more than 1 year of accounting experience to meet the minimum qualifications for licensure. This resource provides both a summary as well as excerpts from statutes and or regulations for those jurisdictions. Appendix 6, starting on page 66, contains links to the Uniform Accountancy Act and model rules, and points out the relevant sections that describe accounting experience requirements. Specifically, note that the Uniform Accountancy Act and model rules include a 1 year experience requirement without any specific attest requirements. 7, starting on page 68, provides an overview of the various considerations regarding the attest experience requirement that the CBA and its committees and task force have had since the 2000 Sunset Review. Appendix 8, starting on page 74, provides a brief summary of the study on attest experience requirement that the CPA conducted in 2014 and 2015. A link to the complete study is available on the CBA website. I will now turn this item back over to Chair Salazar and will be happy to answer any member questions.
All right. Thank you, Mr. Lieberman. Do we have any questions from our committee members on this agenda item? All right, seeing no hands, I would like to ask the moderator to please open for public comments on agenda item number 4.
Thank you, Madam Chair. I've opened up the Q&A panel, and if any member of the public would like to comment on agenda item 4, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We are displaying instructions, and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
All right. And I believe that we are ready to move along. If we have any additional items on there from Mr. Lieberman, I believe we do not. So that I believe that puts us on agenda item 5, overview of the present CPA licensure requirements. So Mr. Lieberman, could you please begin this presentation?
Thank you, Chair Salazar. This item provides an overview of the legislative history associated with the establishment of the general accounting experience requirement and information on the requirements for general accounting and attest experience. The legislative history associated with the establishment of the general accounting experience requirement is found in the background section of this item on page 2. In short, prior to its 2000 Sunset Review process, the CBA had been exploring the topic of increased conformity with the Uniform Accounting Act. included a shift to a single pathway for licensure that increased educational requirements to include a baccalaureate degree or higher with a minimum of 150 semester units, and establishing a 1-year general accounting experience requirement that did not necessitate the need to demonstrate completion of hours in attestable functions. A key rationale for establishing the general accounting experience requirement centered on the barrier to obtaining a test experience created, and many individuals did not plan to work in the attest field. During the legislative process, stakeholders raised concerns regarding the impact increased educational requirements would have on entry into the profession, and that attest functions are the only services that are exclusive to the CPA profession. As it related to the experience requirement, a compromise was reached, whereby individuals could enter the profession under a general accounting experience license. However, if they wanted to sign reports on attest engagements, they would still need to satisfy the attest experience requirement. Under the comments section on pages 3 to 5, staff have included an overview of the general accounting and attest experience requirements. Applicants are required to have a minimum of a year of qualifying general accounting experience in which they can gain public accounting, private industry, government, or academia experience. All experience must be supervised. To qualify for the general accounting experience, applicants can earn experience providing any type of service or advice involving the use of accounting, attest, compilation, advisory, financial advisory, tax, or consulting skills. It is important to highlight that applicants are not required to complete experience in any one specific area or all of the aforementioned areas. Applicants demonstrate completion of the general accounting experience by having their employers submit the Certificate of General Experience form. The Certificate of General Experience form is included in Cert Item 4, Resource Materials, Appendix 2. When supervisors sign the experience form, they are indicating that they have reviewed and evaluated the qualifying work on a routine and recurring basis, and have the authority and oversight over the applicant. It is important to highlight that supervisors who sign the Certificate of General Experience form are not opining on the quality or competency of the work provided by the applicant. Licenses issued with a general accounting experience requirement allow individuals to offer and render the full range of accounting services, with the exception that they may not sign reports on attest engagements. Those individuals who want the authority to sign reports on the test engagements, in addition to completing the general experience requirement, they must also document a minimum of 500 hours of experience satisfactory to the CBA in attest services. On page 4, staff have identified what applicants must complete and perform as part of the minimum of 500 hours. I'd like to stress that the minimum of 500 hours is, and in most cases, the hours needed to complete and demonstrate a competency in the 5 areas identified in page 4 are in excess of 500 hours. Applicants demonstrate completion of the attest experience by having their employer submit a Certificate of Attest Experience form, which is included in Cert Item 4 Resource Materials Appendix 2. When supervisors sign the experience form, they are indicating that they have reviewed and evaluated the qualifying work on a routine and recurring basis and have authority and oversight over the applicant. Additionally, supervisors opine on whether applicants have experience in all of the specified categories and demonstrate an understanding of various applicable professional standards that make up attest-related services. This is a distinct difference from the general experience form. It's time to turn the discussion back over to Chair Ted Salazar, and we'll do my best to answer any questions. Thank you.
Thank you for that overview, Mr. Lieberman. Do we have any questions from our committee? And seeing no hands raised, I would like to ask our moderator to please open this up for public comment, please.
Thank you, Madam Chair. I've opened up the Q&A panel. If any member of the public would like to comment on Agenda Item 5, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Thank you very much, moderator. So now we get to move on to agenda item 6, which is the discussion regarding possible recommendations to the Board of Accountancy regarding experience required for CPA licensure. So with that, I would like to introduce Chief Dominic Franzella to please begin the next presentation.
Thank you. Good morning, members. I am Dominic Franzella, Chief of Enforcement for the Board of Accountancy. So the purpose of this agenda item is to serve as the Cert starting point for discussion on possible recommendations to the CBA regarding the experience required for CPA licensure. The task force will be asked to plot a course of action for future discussion topics related to the evaluation of the experience requirement. As Chair Salazar noted during her overview on agenda item 2, the CBA charged this task force with exploring the necessity and sufficiency of the test experience requirement and supporting the CBA's consumer protection mission. It is anticipated that Cert will take several meetings to reach an answer to the primary question. Staff are seeking guidance and directions on what items, research, or other materials members believe they will need to aid in researching an answer. While not an exhaustive list, members may request staff to gather additional statistics, seek to obtain additional information to provide a greater in-depth review of the impact CPA evolution will have on the licensure process, possibly potentially consider other areas the CBA and its prior committees and task force explored during the consideration of the experience requirement as well. While there are likely several ways Cert could take in its examination on the primary question regarding the necessity and sufficiency of the attest experience requirement, on page 2 of this item, staff have highlighted a couple of options. Again, these were also covered by Chair Salazar in her overview, but again, these could include seek to evaluate the sufficiency of requiring pre-licensure attest experience for individuals that want the authorization to sign reports on attest engagements. This could include items such as minimum number of required hours and the various areas of qualified experience that applicants must obtain. After completing its evaluation, determine that the attest experience requirement could be eliminated. If so, as directed by the CBA, it would need to develop a method to eliminate the attest experience requirement, including those necessary backstops that would be put in place to offset the elimination of any experience requirement, such as noted earlier, possibly an attest accounting licensure registration, attest firm accounting licensure registration. Or after completing its evaluation, determine that the attest experience is sufficient or may need possible modifications. Should the ultimate outcome be that Cert recommends maintaining the attest experience requirement, even if modified, it will also need to, again, as directed by the CBA, provide recommendations to the CBA on how to handle various policy issues that staff previously raised at the November CBA board meeting, and which members can locate on the bottom of page 2, and any additional policy issues identified by the CBA and Cert during the course of Cert's work. The policy issues identified by staff at the November meeting, I won't go into a ton of detail on these particular issues because they are mainly a placeholder should the test experience requirement recommendation be, or should the recommendation be to maintain the attest experience requirement, but they include issues arising from accounting firms that provide attest services when the firm's ownership is comprised solely of CPAs who are not authorized to sign reports on attest engagements, licensees who are owners of accounting firms that want to obtain necessary experience to convert their license to include the authority to sign attest reports, and reciprocal licenses issued under Business and Professions Code Section 5087. Again, we have provided a high-level overview of these policy issues to provide the members with an understanding of future work based on recommendations by this task force. Rather than explore these in details today, this will be discussed in greater depth should the attest experience requirement be should recommending the attest experience requirement be maintained be Cert's final recommendation. There was one item I'd like to note that was not included in the materials, and it relates to how the attest function operates in conjunction with California's mobility provisions. Chair Salazar asked that I provide some connection as to how mobility and attest function in California. So for those not familiar with mobility, these provisions allow individuals whose principal place of business are not in California and who have a valid and current license to practice public accountancy from another state to engage in the practice of public accountancy in California under a practice privilege without obtaining a California license. This is subject to an individual meeting certain conditions, but there are certain limitations related to practicing under mobility, one of which includes individuals that wish to sign reports on attest engagements. By engaging in this type of service, individuals are declaring that they have met the requirements of the CBA's attest experience requirement. As there's no pre-review of individuals' qualifications, this is done via a self-certification on behalf of the licensees, and should they ever be called upon by the CBA to demonstrate satisfaction, they'd be able to do so. So as I conclude the overview of this item, based on the direction by Cert, for the next meeting, staff will perform any necessary research, begin evaluating certain recommendations and how they may impact CBA and its stakeholders, and discuss any timelines to achieve any of the various recommendations under consideration by Cert. So at this time, I'd like to turn discussion on this topic back over to Chair Salazar, and I'll do my best to answer any members' questions.
Thank you, Mr. Franzella. And I think we've sort of come to the heart of this meeting. Member comments and questions? Mr. Cpa?
Yes, thank you. And thank you very much, Chair Salazar. Thank you for that presentation. Just more of a question. Again, I'm learning and going to listen more than talk at this first meeting because it's just good to soak all this in from your great staff. But I was curious, what kind of, has there been any sort of empirical data or surveying of the industry kind of has led up to the determination of this particular task force and what needs to be done? You know, surveying and empirical data from the CPAs and from the industry and from just out there in terms of, you know, the challenges and why, you know, kind of where they're at and where they feel the issues and the concerns are. So I guess that's more my question. It may be in the data that you provided. I've read through the meeting materials, which are great, but I was just curious if there's been what kind of industry surveying or empirical data from those who practice you've been able to glean that has led to us wanting to decide some things here. Does that make sense?
I think it does. And then don't forget when you finish your comment to lower your hand.
Yes.
And then, I don't know, Mr. Franzella, do you want to respond to the last survey or?
I will do my best to respond to that question. During the last survey, during the last review of this back in 2015-16, when the CBA produced its own kind of attest survey, we did reach out to consumers during that window of time related to the attest services and their knowledge of the attest function. I think there's a lot of assumptions that consumers recognize the services that they're requesting might require a separate license, or not a separate license, but at least a licensee who has a designation that allows them to sign attest reports. I believe in the materials, it was a link because of the voluminous nature of the actual report. There were participants we did reach out to consumers. There wasn't a significant response rate. I think there was only around 37 consumers who responded to the survey. So I don't know how much empirical data you can really, or using that empirical data, I don't know how much you can rely on it for relative sample size, but there is information in there, and including what types of services they want. So that's the extent of it, at least from a consumer side of things that the staff or board have related to that topic.
Thank you. Appreciate it.
Nancy, do you have a comment? I mean, Ms. Corrigan?
Yes, thank you. I do. As a practitioner, CPA, as a board member, I guess what I wrestle with are the lack of knowledge of how do other states, how are they handling all of this? I mean, we have a report, we have the appendix that refers to information from 10 states and territories, what the requirements are. You know, 2 of them have kind of like a dual licensing, such as California does. The other 8 on the list do not, yet they maybe have other extended education requirements and that sort of thing. So there are so many states that do not have, of course, as stringent requirements as California does, but are they experiencing, do we know, are they experiencing a high volume of audit failures, not company fraud and that kind of thing, but poor audit service, you know, just failures because of lack of experience of the auditors, the auditing firms, that sort of thing. And how are the states? How is, you know, UAA? How does that all come together? And are they just not experiencing issues? Is everything going fine with them? I know I've heard a little bit about maybe a few states looking into tightening their requirements. I don't really know much about that. I don't know if Mr. Dustin can tell us anything because he is with NASBA and he's on our task force. But I just wonder, you know, I'm more familiar with California, what we experience. We have non-licensees attempting to do audits, doing audits. We have G licensees doing audits, and then we have A licensees doing some poor audits too. But I don't know the extent of it, and I don't know what the rest of the nation is experiencing. So that's kind of a very complex comment, but can anybody, and Dominic, do we have any information, or Mr. Dustin, do you have any response for me there?
Ms. Salazar, I'll defer to Mr. Dustin first, and then I can try to fill in, unless Mr. Dustin would like me to go first.
Mr. Dustin, your hand isn't raised. How do you feel about this?
I'll raise my hand first, and then I'll try to jump in because it's a rather complicated area.
Thank you.
Certainly, a vast majority of the jurisdictions follow the Uniform Accountancy Act, which is 1 year of general experience in various settings. As Ms. Corrigan mentioned, there are some states that are looking toward possibly increasing their experience. Yet at the same time, out of that group of 10, I'm aware of at least 1 jurisdiction that is looking toward reducing their experience requirement to be more in line with the Uniform Accountancy Act. As I said, it is a rather complex area. Mr. Franzel, I do have, I guess, one question for you, and I don't know that you have the data right now. I'm curious, you know, with your experience with respect to mobility and out-of-state firms performing test services in California, certainly there are many firms that may be practicing under mobility from a state that have lower experience requirements. And while I recognize that the individuals who are signing the reports on behalf of their firms are certifying to CBA that they have the necessary experience, have you come across instances where that may not be the case with respect to services performed, you know, lower than professional standards?
Ms. Salazar, would you like me to respond?
Oh, sorry. Yes, thank you.
So I would need more time than today to kind of look into that particular piece of information. I know we have taken action against firms who are registered, we call them out-of-state firm registrations that are distinctly different than California registrations or licenses. So I would need to take a look to see what were the grounds for discipline that we sought or the board eventually took on those firms to see if they tie back into, was it something reciprocal from another state? And that was the sole basis for the registration being disciplined here, or were there other issues that we identified from a complaint? So that's something, again, I'm happy to bring back at the next meeting, along with any other enforcement related statistics this particular task force believes are appropriate for evaluating this topic.
Thank you. And we have another comment from Ms. Corrigan.
Yes, thank you. I know throughout the materials that were provided, and they were excellent, by the way, that mention was made of our CPA's Qualifications Committee, our advisory committee, and at various times they commented on the 500-hour experience requirement. Was that sufficient, etc. And I know some of those comments were some time ago. Have they made comments such as that more recently, based on, sitting down with the candidates and sometimes their firms and evaluating the applications?
Thank you for that. Mr. Franzella, is that something that you would be able to speak to, or could maybe bring that information back later?
I'll actually defer to Ms. Center, being the licensing division chief, to help answer that question, if that's okay with Ms. Salazar.
Yes, please. Thank you for that direction. Ms. Center?
Sure, happy to respond. The QC has not recently had conversations regarding the 500-hour requirement and whether or not they believe that's sufficient. I think that is a question that this task force may want us to take to them, and I believe that would be appropriate for you all to have a conversation about.
Thank you very much. And, I guess I would just like to pause here. We've got another question coming. There are no bad questions. I think the bad questions are the ones that aren't asked. There are members of the public who aren't familiar with these issues. I know as a board member, I often ask staff to refresh my memory about a lot of our very detailed rules. So this is exploratory. And so all questions really at this point are welcome. And I would repeat, I think at this point, our goal is to identify the questions and the information that this committee needs or wants in order to be able to make a decision. So I appreciate these questions, and I'd also like to call on Mr. Simidian next.
Thank you. I hope you still feel that way about there are no bad questions after questions here, but I maybe just some broader context. As auditors, we kind of use this concept of what can go wrong as sort of evaluating risk and assessing what procedures would be performed. So I'm trying to understand, and I guess this might be a broader perspective, like what can go wrong if we eliminated or took away that requirement. And I bring that from my perspective of, in the firm of the size that I worked in, the likelihood that somebody without that proper level of experience could get even remotely close to being in a position to sign a report without the appropriate level of training and experience and stuff is something I can't quite, I couldn't envision a scenario like that, but I've got a pretty limited perspective around that. So and maybe this is to the other committee members or even the staff, can we walk through like maybe a couple of hypothetical scenarios where the lack of that experience, how that might manifest itself, and potentially individuals shouldn't be taking on that responsibility, or impact that have on audit quality? Because I think that might help me understand the relative importance of the 500.
And I appreciate that. And I see Ms. Johnson, so we'll call on you next. I don't see staff raising hands. Maybe if staff want to do that, if there's a particular question that they're very excited about answering, that will save me from trying to remember which staff person should be best directed to. But I'll make an effort for that. We do have, after someone qualifies and is licensed, if there is a bad audit, there is, of course, the disciplinary process, there's two things. There's the peer review for the attest service requirement. That is a process that does take some time. And there's that issue of, do they pass their peer review? And then also there can be discipline arising out of the peer review results, or a complaint by a consumer that can elevate an issue at any time to the board. So we do have a process to deal with it in the event that someone does conduct an audit that is not meeting professional standards. I don't know if that's a helpful answer. And then I don't know, staff, would you like to add anything into that response before I bring it to Ms. Johnson and then Ms. Corrigan?
Ms. Salazar, this is Dominic. I will, I can, but before I do, I'll provide an opportunity for Ms. Corrigan and Ms. Johnson to provide their input, and so mine might not be duplicative in nature.
Fantastic. We'll circle back in the order I saw the hands go up. So Ms. Johnson?
Thank you. My questions, I guess, come twofold. Currently, we do have the G and the A license, and has there been any research or feedback on the confusion that might be causing the public? And when the public does see that an individual has a license, is there any feedback as to if the automatic assumption is that that person has attestation experience or rights to perform attestation? And then I guess the third is kind of like three questions in one here. We have 500 hours of attestation experience required in order to get the A license, but CPAs perform many other functions other than audit and attestation. And so how do we reconcile the experience level requirement? I know that in order to perform an attestation, only a CPA can perform that service, but CPAs prepare taxes. They're general accountants. We perform many other functions. So how do we separate out that extra requirement of experiences to perform attestation engagements without confusing the public on the quality of the A license versus the G license?
Okay, that is a great question. And you asked a couple, so I'm going to continue on to Nancy, and I think we're going to circle back to a lot of these. Nancy, Ms. Corrigan?
Yes, thank you. I kind of wanted to respond to Mr. Simidian's excellent question, comment, and also mentioning that there is peer review. Peer review happens every 3 years once you get on that in that cycle. So it is after the fact, unfortunately, that's the only way that it can be. But as far as the importance of gaining experience, a test experience, we all learn a lot in school. We're tested, we pass the CPA exam, etc. But that is one thing, and going into practice and making it real, putting the pencil to the paper, so to speak, is something different. The audit process has really evolved to where it is so circular. It involves, planning and risk assessment. And if this happens, then I take this path over here. But if something else happens, I take another one. It all has to tie together in the end. And an inexperienced person wouldn't even begin to know how to make those judgments. There's so much subjectivity. This happened, and therefore I next take this path, or there's a problem with the client, etc. They just wouldn't even know where to begin, and it does take time to get that under your belt. So the one thing that really scares me is, how do you take somebody who's educated, very smart, does very well, great grades, and then just transplant them into being like an attest type auditor? How can we guarantee, and nothing is 100%, right? To make sure that, there's some safety net where everything just doesn't go wrong. And that's the part that I'm wrestling with. I was talking to staff recently and saying, doctors go through a residency, and that prepares them and gets them ready. I know that not all professions do that, but that residency or our experience requirement, things like that really prepare that professional. And yet there's so much on the job training and learning how to use judgment. And gee, this happened last time in this other audit, and I can apply that knowledge here. So you don't walk away from school with your degree just ready to go, in my opinion. So I hope that helps.
Thank you for that, Ms. Corrigan. I've got a few hands up, so I'd like to call on Mr. Franzella first, and then I believe we had Ms. Johnson and Ms. Hines.
Thank you, Chair Salazar. So I guess to circle back to Mr. Simidian's question on hypotheticals, I think the primary hypothetical here is I recognize that with larger and even mid-sized firms, that an individual who likely completed the attest experience requirement would not be an individual who would be signing an attest report as soon as they received that license. However, I think the most tangible example would be if an individual just completes the general experience requirement without an attest level. Let's say we didn't have the attest experience requirement. That individual is allowed, without having demonstrated any competency in the attest practice, to go out and perform an attestation engagement. And I think that's always been some of the reservations with some members' concerns related to this topic, is that there's I'm not trying to pick on attorneys, but an attorney passes the bar and they're able to go out and perform any range of the services. Now, they have to be competent and qualified just like a CPA, and they shouldn't be engaging in practice that they aren't qualified to do so. But the A license at least provides some level of assurance that an individual is competent in the attest environment, or has demonstrated some minimum competencies in the attest environment. So I think that's probably the most tangible example, is that a G licensee, sorry, not a G licensee, but an individual with general experience, if we did away with the attest, could immediately go out and hang their shingle and start performing audits without having ever demonstrated audit capacities.
Thank you for that response, Mr. Franzella. Ms. Johnson?
I just wanted to say that I actually am in agreement with both Ms. Corrigan and Mr. Franzella in this respect. Come from a unique experience to where, I did have internal audit experience. However, and I, passed the CPA exam, I teach accounting, but it would be difficult for me to envision someone not having actual attestation experience being able to sign off on an attest engagement. And that brings me back to, is 500 hours enough to qualify an individual to sign an attest engagement? Because I have experience with professionals who have an A license, and I'm just not sure that I would be comfortable with those individuals signing an attest engagement, given the level of understanding of accounting that they have, which has been, in my personal experiences, less than what I have had. So just my comments.
Well, thank you for that. And as people speak, don't forget to lower your hand. And I'd like to move on to Ms. Hines, who's been patiently waiting, and then Mr. Simidian.
Thank you, Ms. Salazar. This is a lot to process. And, it's notable that we did have this, evaluation, similar kind of, review in 2016 and then in 2013, and no recommendations were made to eliminate the attest experience requirement or to increase the number of hours, required for licensing for attest experience. I have not had the ability to go through the report from the last, committee or task force that reviewed this back in 2013. It's a 400-page document that I'm sure would answer a number of these questions, but so I'll profess that before I start, rattling off my questions. But I wanted to go back and sort of address or comment about both Mr. Simidian's question and then the concerns raised by Ms. Corrigan. Building on Mr. Simidian's question, I think it would be helpful for staff to provide some report, current data about any actions that have been taken regarding audits or complaints around attestation reports to help the task force evaluate and look for any trends that may have arisen as a result of the attestation requirement or the attestation service, because I think that would help us to look at whether or not the experience requirement is adequate or whether or not it's it's necessary. Because if there's not a problem, then what is our purpose? What is our goal here? Ms. Corrigan raised a concern about the need for there being specific experience with attestation to avoid certain kinds of problems. And I think it's notable to look at what other states are doing regarding providing this oversight of this kind of service. Because it's notable that when it was reported about which states have attestation experience, I don't think there are states that have as large a number of licensees as California. And I think that it's notable that not to see states like New York or Texas or that have a specific attestation license, that do not have a specific attestation license. It would be helpful to know what they do regarding this kind of area of expertise, how they oversee and protect the public regarding this kind of service, and how they manage that without having a specific attestation license requirement. I had a couple of other questions that are completely unrelated, to the current discussion, but I'll just raise them, and they might be a number of them I think are things that the staff is going to have to come back to us about. But I feel like in previous meetings, we've talked about their concerns have been raised about the lower numbers of licensees that are seeking the attestation experience license and the impact that could have on the availability of that service for consumers, particularly as we're seeing the mobility the changes in mobility regulations come up. Could we see in the future, as the number of licensee getting, the specific attestation license in California goes down, California consumers going to out-of-state licensees or accounting firms to get that service, rather than pursuing a California licensed, a California accountant or agency or company firm that has the attestation license. So I think that's something to sort of go back up and look at. And completely different from what we're talking about here, but in the document, I think this is Appendix. Just a moment while I find what we're looking at. This was in item number 6, the discussion regarding possible recommendations to the board regarding experience required for CPA licensure. On page 3, I think, there's pages 2 into page 3 through 4. There's a discussion about firms not having the attestation license, but then audits being signed by employees of the firms that have the attestation license. This is a very complicated issue that was raised in this memo. I thought it was a very well done memo that raised a very complicated, a very complex issue that I think we should, our task force should get into a bit more. But this idea of whether or not we need to require the firm to have the attestation license, or whether it's sufficient to have the employee have the attestation license, and sort of the issues that were raised around that. I'd like to have a better understanding of this issue, because I don't think I don't completely understand it. I understand there's an issue, but I don't completely understand what the issue is. And I think it would be helpful to have a larger discussion about this issue and the concern that's raised. The other thing that it sort of flagged for me was whether or not, if we were to start imposing more requirements about how the attestation license could be utilized, whether it's with the firm or whether it's with the individual, do we start running afoul of that North Carolina Dental Board, case that imposed limitations on licensing boards to regulate professional practice areas? Because my recollection of that, and I just did some quick, looking into it just to kind of refresh my memory a little bit, but my recollection was that there's some the antitrust laws impose, the Supreme Court interpreted that antitrust laws impose some limitations on licensing boards in their ability to regulate the practice, in their ability to regulate practice areas. So I don't, again, this is really complex, and I'm just, opening the door for more discussion. If staff and if the other members of this task force, think these are issues, but these are the things that just kind of came to mind in the, sort of opening this Pandora's box of issues, that we're faced with today. So I don't necessarily expect a response, because I brought up a lot of things, but in the spirit of, there being no bad questions, I decided to give it a go. So thank you.
And I appreciate that. So I kind of made some notes. Hopefully I'm keeping track of everyone's questions here reasonably well. But Mr. Simidian has been very patient. So I'd like to invite you to speak.
Oh, thank you, Ms. Salazar. And I to the extent you want to move on, I just wanted to respond to the response to my question. And I appreciate the context around that. And I think this helps me anyway, think about what other safeguards could be proposed, and maybe there's some already in place, but what other safeguards might be proposed to the extent there was a change to the requirement, the attest experience requirement, that could address that type of scenario, or some, I'm sure there's others. That wasn't the only scenario, I'm sure. But I mean, if we're dealing with that risk that individuals are taking on this responsibility, and I use that word intentionally, responsibility, without the appropriate level of necessary skills and including that experience, again, maybe there's some other ways that could be addressed. I would just argue that, 500 hours in the context of a public accountant is about 10 weeks, right? So whether that's at 10 weeks of someone's experience or no weeks, I think we have the same underlying issues. Somebody setting up a shingle as described, and providing those types of services potentially without any safeguard in place. So it seems like you'd have to have that anyway. And I'm just not as familiar with what those safeguards may be if they're out there. So.
Thank you for that comment. I think it's an important perspective to hear, and I think we're going to dig into those. Mr. Franzella?
I just wanted to quickly follow up on that 500-hour thought process I want to just emphasize, and I know this goes all the way back to when we dealt with what was called the Teal Taskforce, who took this up back in 2013, and we had a lot of discussion around it. The 500 hours again is a minimum. It's definitely not it's the floor, not the ceiling process. And regardless of the number of hours, it could be 3,000 hours until such time as the supervisor. And again, it's supervisor dependent. I recognize that can be, one supervisor has a different interpretation than another. You have to get signed off on all 5 areas before you get to that, regardless of the number of hours. So I know oftentimes we look at the 500 hours as a low benchmark, and while it might be, that used to not exist, and I don't recall when that came into effect. I want to say in the 90s or maybe early 2000s, stakeholders started pushing for what's a number? And the board came up with 500. It used to just be based on those professional standards or those areas of practice within the audit. So I think those are things, again, as this committee looks at it, one of the topics was, it could be necessary and sufficient as is, when it's all said and done, but there could be some discussion about, yes, it's necessary, but it's insufficient in terms of the hours need to be increased or modified or eliminated. And there could be discussion on those practice areas, a more robust look at those. I mean, there's anywhere they can go. I just don't want the 500 hours to kind of be the hang up of some kind of setting the floor discussion.
Thank you for that. Mr. Simidian, you have a hand up. Is it a new question? Okay, no. We have Ms. Johnson.
Thank you, Mr. Franzella. I think that kind of helps set my mind at ease here regarding the comment I made on the 500 hours. It is a minimum, and I think our backstop, if I understand, I'm reading into your response, really is the supervisor is signing off, not just that the individual had 500 hours, but to their level of experience within that 500 hours. So that could potentially just be our backstop without imposing any additional restrictions or increased hours as a minimum on that.
Thank you, Ms. Corrigan.
Yes, just one little addition to that, recognizing it is a minimum and a guideline and the completion of certain steps, but also that the supervisor feels that the candidate has demonstrated an understanding. That's really important. We've all had employees over the years, they can do, but they never understand what they're doing. And so they have to be able to basically then go out on their own, and they could be in charge, plan, and complete a small audit on their own. And so it's pretty 500-hour minimum guideline, whatever. There's really a lot wrapped up in that, and comprehension, understanding it is one of those.
Thank you for that, Mr. Cpa. Sorry, and then we'll go back to Mr. Franzella.
I think Ms. Corrigan raises a really good point in terms of just the sheer understanding along the way, and I learning in this first meeting, but is there potentially an open idea of possibly being able to gauge their understanding along the way of that 500 hours? In other words, is there a way to gradate that or assess their understanding within the first 150 hours and then the next 300 hours? Or again, is there a possibility to, Ms. Corrigan brings a really good point, which is understanding that and having that understanding along the way, but is there a way to better assess that so that they're grasping that in certain quarters or percentiles of that process? Just a thought.
Thank you for that. And then I believe Dominic had his hand up previously, and then we'll go back to Ms. Corrigan.
Thank you, Chair Salazar. So I'd like to address maybe two things. One, I want to circle back to, I believe, a question Ms. Johnson asked in her, I think it was a 2 or 3 part question. I think we've answered most of them, but I think there was one piece that was still left outstanding. But one of the things we could consider, this committee may want to consider, is Ms. Sender's team the Qualifications Committee, one of the elements of their of licensing division is the Qualifications Committee. If it would be something this committee would find, or this task force would find valuable, we can have the QC chair potentially provide an overview of how that committee performs some of its functions related to supervisor review, work paper review. I think it's called Section 69 reviews, to provide a level of context of, again, this goes back to that bridging the gap between the minimum hours and the competency element. Those firms that get called in for a work paper review or Section 69 review, how the committees kind of methodically work through, okay, we see these number of hours, we see this is all signed off on. They're actually testing the supervisor's knowledge. That's the kind of test that kind of goes into one of those reviews is, does the supervisor truly understand what they are actually signing off to? And is often the case. I wouldn't say it's regular, but it's not uncommon that we find that they don't, and we defer those applicants. So it might be it might be something we can have added to a future meeting where the QC chair, in consultation with Ms. Center, they can present on how that kind of process works, how they get selected, and that robust process that kind of exists for that. The other part, getting back to Ms. Johnson's question, I believe there was a question as part of that you'd raised about consumer confusion between the G and the A license and whether or not that comes up. Yes, it does. It also comes up among CPAs. Majority of the CPAs actually oftentimes don't recognize, and I will say this is more on the attest side of things, the individuals who have the attest license oftentimes don't recognize what some of the limitations of a G licensee are, in as much as compilations don't fall within that. And I believe that's one of the reasons why Ms. Salazar added that to the opening remarks, is we differ from other states, or what professional standards would call a test. And so here, a G license, an individual with general experience can do the compilations and fall outside attestation. But there are those issues in individuals both nationally and within the state who are don't recognize that it's not two licenses. We try to go about our best to explain that it's not two licenses, but there is a tier to what a license can do based on that level of experience.
Thank you for that. And I appreciate Nancy's efforts and Ms. Corrigan's efforts and Mr. Franzella's efforts to circle back and address specific comments here. Ms. Corrigan?
Well, yes, and certainly that brought back memories, Mr. Franzella, when I was on the Qualifications Committee. Those sessions are closed session with the candidate, the employer, and the opportunity to really determine what the supervisor, and in addition, what the candidate does understand. Now, understand that not 100% of the applications are reviewed in that way. It's if the application has a question, or maybe the firm has a track record of signing off before they should, et cetera, et cetera. Yes, along the way, as a supervisor is reviewing the staff work, signing off on work papers, et cetera, reading memos, that judgment is happening along the way. It's an accumulation of knowledge and experience. It isn't just, well, let's get to the end now and see, did they know what they were doing? It is an accumulation. Over the years, some candidates have been approved with less than the 500 because, perhaps they completed a very complex audit and enough of the areas, that occurred. That is unusual. And, but that can happen. And again, the 500 being a guideline, like a minimum guideline, but that has happened in prior years. We may be more stringent today, but it is that process that happens. And then certainly you have some that just take a lot longer to absorb and understand and able to function. And it may take 3,000 hours to do that, or maybe never, so I hope that.
Thank you for sharing that. And at the moment, I don't see any hands raised, but there was a question. I've lost track of who asked it or referred to it, but there was a study done in, I believe it was 14-15 that was presented at the March 2016 Board of Accountancy meeting. Since I was on that, it was 400 pages. I'm going to rely on memory, but I would share with you the things that I recall from that conversation, and that context might be helpful. There was no, of course, as everybody already understands, and it was referred to here, there was no recommendation to make any change to the attest function, but there was a great deal of discussion about, was 500 adequate? And there was a strong sentiment, I believe, among the committee that more experience is better, because most people said, wow, you know, it would be really hard to do a quality audit with only 500 hours. But again, the idea was it was a floor. It is that minimum. And professional standards today that govern CPAs require you to perform work that you have the ability to do. So there really is a process. My wording is incorrect, but there is a process in place where professional judgment is supposed to be done that would keep someone from having no experience and then taking on an audit well outside of their ability to perform competently. So it's not as though there isn't any guideline to it. But the issue was, what is the right number? Some people argued that 2,000 hours wasn't sufficient to do a truly, truly good audit, and it would take years, more like an apprenticeship program, to get there. And so my recollection was there wasn't a better number, and so the 500 was left as a benchmark, but there was a lot of conversation about it is not a guarantee, and the very complex processes in place within the Board of Accountancy are the way we function to protect customer safety around it. It isn't just the 500 hours. We have a lot of mechanisms that work. Again, staff may have identified a few areas where we need to do some backstops to those mechanisms, but that was part of the discussion. So I don't know if that is helpful. The other thing that I recall out of that was there was a very extensive stakeholder survey with nearly 10,000 responses. And my recollection was that stakeholders overwhelmingly supported the experience requirement. That was not true for the subsection of candidates. They would have been very happy not to have an experience requirement. But for those in practice, it was, as we discussed, you know, there's an understanding of how difficult it is to perform a quality audit. And so that was the concern, was that this is valuable. So, you know, I come to this with the last time we surveyed, there was a lot of support within our profession for continuing this. So it becomes a question of, is it still necessary and sufficient, and how do we get there? So just some context from the things that I recall from those time periods and some of those discussions that I'm hearing continued again today. Any other comments from our committee members? There is one item that jumped out at me when I read the materials. From my recollection, somewhere in the materials, I believe I saw this in the 2015 survey materials in our workbook. I believe there were 5 states, 5 jurisdictions with attest experience requirements, including California. And today, if you go to page 45 of our materials under the select state experience requirements, it's interesting, I'm only seeing 2 on this, or rather 3 on this list, ourselves, Guam, and Iowa. So it's interesting to see that in the past few years, changes have happened across the US, and fewer boards are considering this function necessary given all of the other processes in place. Or at least that's what I'm reading into the decrease. One question that I might have would be whether or not staff could work with NASBA possibly to do an update of the poll that we did in 2015, just to see where various states are today. Are they considering increasing, changing, eliminating? I'd be curious to hear if these are on other agendas. Mr. Franzella?
Yeah, we can definitely work with NASBA related to seeing if any states are presently considering either removing or adding. I know NASBA, when the data we provided was a full review NASBA had performed of the states to get where they're at today, which we didn't really have back in 2015 when we did this. The other question that this task force may want to consider, and I don't mean to put Mr. Dustin on the spot, but back in 2019, there at least was some initial discussions related to attest firm experience and personnel who were within the attest firm, and whether or not NASBA is that one of the things that NASBA is taking up over the coming year, or anything related to that, because that might dovetail into why states may or may not be seeking to adjust their attest experience requirement, if any.
Thank you for that. I'd like to call on Mr. Dustin to respond, and then Ms. Corrigan.
Thank you, Chair Salazar, and Mr. Franzella, thank you for the question. It certainly has been a topic of a lot of discussion with the Uniform Accountancy Act Committee, which is a joint committee of the AACPA and NASBA, so it has representatives of both. Several years ago, perhaps 3 or 4 years, perhaps more, the group, the committee, considered whether or not they should look toward more of a firm designation where the firm would be responsible. And I believe originally it was 2,000 hours of experience over 5 years. The committee created a task force. The task force had some discussions and found that in some instances, changes that were occurring in the profession, for example, with respect to billing, where firms, rather than doing hourly billing, were moving toward value billing, may create problems. Others suggested that if you're in practice, you certainly know how many hours you're spending, whether you do value billing or hourly billing. So is that really something to consider? Certainly, there were concerns expressed that if you establish a threshold for the number of hours, what is the appropriate number? If you're a large firm and you have a large book of business, perhaps that person in charge of those engagements would be able to fulfill 2,000 hours over 5 years. However, if you're a sole practitioner or a smaller firm, is that threshold too great? And should the hours be based on total engagement hours, or on, the partner hours, the owner who's responsible for the engagement? Certainly, when you look at traditionally the way audits are staffed, the managers, the supervisors, the staff accountants spend a lot more time than the partner level, who are more or less reviewing work. So should it be based on engagement hours versus partner hours with respect to engagements in the calculation? Others suggested that perhaps we should look at things like continuing professional education, and should you almost have a point system where it's not just limited to actual hours, but there are other relevant factors that should be considered, like professional competency as you move forward. So it is still actually the task force has been reestablished in the last 6 months. They have not had any action recently, and I don't believe anything will happen at least before the end of busy season this year, April 18th of 2022. And I don't see any suggestions coming in the near term with respect to that, but discussions do continue. Thank you.
Thank you for that, Mr. Dustin. I think that's really helpful background. We have a hand up with Ms. Corrigan.
Yes, just kind of going back and having staff gather information, perhaps work with NASBA, which is very much appreciated. As long as I appreciate having the count, of course, but understanding how the states are able to move away from, in other words, what safeguards are in place, will help me anyway to make a decision, my vote for this task force. Uniformity counts for a lot, but I think California, with our volume and everybody coming in, working here, mobility and everything, consumer protection is foremost. And I don't want to just change because everybody is. I really want to understand what the safeguards are so that I am comfortable changing. I was wondering too, Ms. Salazar, is this a good time to address maybe the question Ms. Hines brought up about, if firms doing a test work where the owner is not an A-type licensee, or is that for or do we want to briefly just touch on that so she and others have a little bit more information, or is that for another time? Just a thought.
No, I appreciate, Ms. Corrigan, your helping keep track of some of these issues. I would like to maybe to come back to that, but before we do, we've been talking about an awful lot of stuff for quite a while. We don't normally do this, but I would like to just pause for a brief moment and ask if there are any public comments. I know there was a hand raised. I've been told that there was a hand raised by one of our attendees briefly, and it's been removed. But I would just like to ask our moderator to please step in and open up the public comment discussion at this point to see if there is any input from those that are following us virtually that they would like to ask questions or contribute to discussion.
Thank you, Madam Chair. So I did open up the Q&A panel. If any member of the public would like to make a comment, you may type comment in the field in the lower right-hand corner of your screen, submit it to all panelists, or simply raise your hand. And I do see we have a hand raised. Just a reminder, you'll have a 5-minute time limit. Just for the sake of time, I'll give a 30-second warning. And Manuel, you should be able to unmute yourself now. So let me try that one more time. So Manuel, you should be able to, there you go, you're unmuted.
You hear me?
Yes.
Hi. Hello, Chairwoman Salazar, former fellow board members. Mr. Franzello, you're looking good as always. My name is Manuel Ramirez. I'm a former chairman of the California Board of Accountancy, and I had the pleasure of working with Ms. Katrina Salazar the last time we revisited this issue. And I just wanted to make sure, Mr. Franzello, that when we do present the information to the committee, that we consider not just what's happened in the last 5 or 10 years, but if it'd be possible to provide the committee members a historical context. I can recall passing the exam, sitting for the exam back in the 80s, and it was a 2-year requirement of work requirement under a CPA, in addition to the 500 hours, in addition to steps. And I just worry as a former board member, as our obligation is to protect consumers, that we're continuing to lighten requirements when we should be just holding the standards. And I understand the Big Four have done a great job of eliminating requirements to create CPAs nationally. But that doesn't alleviate our obligation as board members, current or past, in protecting consumers in the state of California. It is only through that experience of attestation where we learn how to identify and look at financial statements, which, to Ms. Johnson's question, is the basis of the tax returns we prepare, which is the basis of the financial statements that banks lend on. And I just wanted to remind the board that I completely agree with the retention of the 500-hour. If there's additional steps that we want to revisit, to include planning and other substantive testing so that CPAs understand how to evaluate those financials, I think that's great too. But I would just hate to see a further softening of the requirements. Certainly, the Board of Accountancy has done an exceptional job for over 100 years, and I'd love to see it continue to do so. Thank you.
All right, this is the moderator, and I see no further requests for comment. Would you like me to close the question and answer panel?
Yes, please.
Okay, it's closed.
All right, thank you, and thank you for calling in, Mr. Ramirez. It's nice to have public comment. Even though we are, again, in the middle, we will open it back up for public comment again before we close out this agenda item. But I think that input is good to hear. I think if I recall where we left off was there was a request to dig into a little further sort of the administrative impacts that we're seeing of our current dual license process. And so there is the issue of sort of helping the committee understand the intricacies of the owners of accounting firms that are G licenses and what that means. Mr. Franzello, are you comfortable digging into that a little bit more at this point to sort of review some of those and give examples?
Happy to. So if members want to turn to, I guess it's we're on agenda item 6. It's on page 2, bottom of page 2, carrying on to about the middle of page 4. This actually was primarily the genesis for a lot of what this task force came together to kind of discuss. And this issue came up. We experienced it once, then we started experiencing it on a couple of occasions. And so this was kind of the genesis for some initial discussions about creating a task force. And then we had some other items that started to kind of percolate as the board was addressing questions around this topic. New areas, like sub areas within that whole topic, started to come up. So there was this kind of discussion about creating a task force to kind of look at the attest experience requirement, and if it's decided to be maintained, how to answer some of these policy questions. So in essence, accounting firms that provide accounting firms aren't licensed like individual licensees are. There's no general or attest experience as it relates to an accounting firm. An accounting firm obtains its license based on the individual owners. Once issued, that firm doesn't necessarily have any limitations on the services it can perform. It's more the partners or shareholders, owners within the firm that have those limitations, and whether or not a firm can sign an attest report, such as an audit or a review. So I want to say back in 2000 and probably around 2007, 8, the board started recognizing that this would potentially become an issue for consumers to understand if there would be a concern about some of the owners not being individuals who could sign attest reports, but having the firm do attest work based on other employees within the firm. And it actually developed a regulation at that time to require these firms to at least notify their clients about the fact that none of the owners were authorized to sign the attest report. However, it didn't preclude the firm from performing the work through another licensee within that firm and authorizing that licensee to sign the report. So I want to say back in like 2019, we started receiving some complaints around firms that were performing this work, finding issues with the actual engagements, not meeting professional standards, and then some of the hurdles we were facing from a disciplinary standpoint against the firm, the signer, how the owner interplays within that because he or she is not actually authorized to sign the reports. And so the board started discussing this through its Committee on Professional Conduct. And actually, I think at the top of page 3, these were some of the initial areas that these 4 bullet points that the board had adopted, or CPC recommended and the board adopted to make some modifications to how an attest firm with solely G licensee ownership would need to continue to practice, such as disclosing to their peer reviewers, because I don't believe peer review actually looks at this particular issue based on conversations I've had with the administering entity. They look at a number of things about the firm, but not necessarily whether or not the owner of the firm is actually licensed to sign these engagements. So disclosing that to their peer reviewer, include in the engagement letter the actual, again, we have it right now that they can either do it through the engagement letter or through notice on their website that the ownership doesn't have anybody who can sign these reports, but it actually doesn't require them to say who's signing the report, so that a consumer could check out that licensee that the firm is authorized to sign the report to see if that individual has had discipline against their license in the past. So the board was going to modify the process to require, one, that it only take place in the form of the engagement letter through that notification process, and that you have to identify who that individual is, including their license number so that that consumer can go on the website, identify who it is, and check about their disciplinary history, if any. One of the issues we faced from an enforcement component was while the owner of the firm, again, the firm in the accounting profession, obviously the CPAs on this call know, or this meeting know, that it's the firm whose name is signed on the report. It's not actually the individual. So when the report is issued, it's issued on behalf of the firm. And we were running into issues from an enforcement component where we couldn't extend the negligent acts performed by the firm to the owner because the owner actually didn't perform the work. So the owner didn't actually take responsibility for the negligent act. We could extend some things to the owner, but not as we did to the license, the individual they authorized to sign the report. So we could actually the board was able to bring action against the signer in a more concentrated disciplinary action than they could against the owner, who, really was outside the responsibility in the structure that California has. And so the board was looking to require owners to take on that responsibility. And then the last thing we were concerned about is, again, the accounting firm has the engagement. They own the work papers that the firm produced. When that licensee who might have signed the report left the firm and was called on to answer questions related to the engagement, would the firm release those work papers to that individual, and concerns around being able to properly defend themselves if necessary. So we were going to make some modifications there as well. The staff were working on those in conjunction with the board, but have paused those endeavors based on this task force. Because if the task force ultimately decides to eliminate the attest experience requirement, these are significant regulatory or statutory changes that would take considerable time and staff resources. So before we continue plotting down that path, we want to make sure that the attest experience requirement is maintained. So we paused on that, and that's kind of one of the areas that's brought it here. We ended up with a wrinkle within that particular issue that we talk about, and I want to say it's at the bottom of page 3 that carries on to the top of page 4, relating to, in California, unlike other states, we don't require sole practitioners who operate under their own name, or who operate as a DBA but as unincorporated to register as a firm. And so it could be ABC Accounting, and it's just Joe Smith CPA doing business as that. So it's called a fictitious name permit. They are a firm for all intents and purposes in California. However, that individual whose license might be with a general experience requirement may have employees within that firm and within that structure, and they authorize an individual to sign on behalf of their license doing business as, say, ABC Accounting. The question came up, does this circumvent the G license issue, where the license itself is the basis for that individual practicing as a firm? Can you elevate that G license to an A license, in essence, by having somebody who's an employee sign on behalf of your DBA and circumvent the general experience requirement? So these issues created a gray area for us that came up. So again, that was probably more of a deep dive than I was prepared to do today in some respects, and probably more than we were probably planning on touching upon today. But those particular issues should attest maintain, regardless of any modifications to the attest experience requirement, we'll all need to kind of circle back to at some point with this task force to go, okay, well, we maintain the attest experience requirement. We may have made we're recommending some modifications. Here are how we suggest the board address these issues in terms of increased consumer protection around this particular issue. So I'm going to stop there and see if I created more issues or questions, and I'll turn it back over to Ms. Salazar.
All right, thank you. We have a hand up by Ms. Johnson. and then Ms. Corrigan.
Thank you, Mr. Franzella. That was very helpful to me to understand what some of those issues are, especially in relationship to the owners of or the partners of the CPA firms, which got me to thinking of just some additional questions. If we decided ultimately to replace the 500 hours of attestation experience, is there some type of additional education or CPE that we could require that the partners of firms would have to take in order to perform, for their firm to perform an attestation engagement, so that the partners would ultimately be reliable versus the individual employee that may be a CPA? Just the question.
Thank you, Ms. Corrigan.
Yes, Mr. Franzell, that was a very good summary. Thank you. And I just have one little point, one little item to clear up on peer review, in case we have any peer reviewers listening. In planning and preparation for peer review, information that a firm submits is background and history of the firm, the owners, their experience. They should be saying whether they're a G or an A license. And if they haven't, the peer reviewer should be asking that question. And then the peer reviewer takes a sampling of engagements by, let's say, owner or signer, so that there is a sampling of all of them, in addition to some required ERISA type audits, A133, certain kinds of engagements are required to be looked at. So it's not 100%. And so when the CBA initiated legislation to have those firms, inform a peer reviewer, the really important thing, which you mentioned, Mr. Franzella, is that they are informing the client, I'm a G licensee and I'm not authorized to sign your financial statement, but this is the qualified person who will be. And so that sort of tied that up, so that all the way around, it completes the circle and everybody knows. So they do gather information, excuse me, about the firm, but it's more of notifying the consumer, the client, if you will. Thank you.
Thank you for that. We have another hand up with Mr. Dustin.
Thank you, Chair Salazar. Ms. Corrigan, you raise an interesting issue for me, I guess, and it's because I hear other issues related to peer review around the country from time to time. I know that the society in California is the administrating entity for peer review in California. However, my understanding is that when the administrating entity performs its peer review, it does so in accordance with AICPA peer review standards, that they don't necessarily look toward state statute or rules with respect to other additional steps that need to be taken. So I guess I would ask staff to clarify whether the peer review team, the team captain, makes any sort of assessment with respect to the owner or partner who's in charge of the engagements, other than just identify whether they have a G or an A license. What do they do beyond that when they have that information? Because it's not part of AICPA peer review standards.
Thank you for that question, Mr. Dustin. Mr. Franzella?
So I believe actually Ms. Corrigan touched on the majority of things that the peer review team captain perform prior to the engagement. I will say in my discussions with representatives from the administering entity, it's not our understanding that they actually do perform a review. They might inquire about ownership's experience and their history, but that doesn't necessitate, like you said, the national standards don't require them to understand what if there is a license restriction per se on that owner as it relates to their G or A license, because it's pretty unique to California. And those standards are used nationally and built around that kind of thought process. So most states don't have this issue of does the individual have a G license versus an A license. So whether or not how the AICPA, and the AICPA and American Institute of Certified Public Accountants is the peer review program provider in California and is the sole program provider, how they would react to an inclusion that this now becomes part of the requirement that sits kind of outside of the national standards. I don't know, but I believe it's something the board had believed was important because it's something that it would add to the risk assessment I believe a firm or a peer reviewer should be looking at when considering that firm's peer review. You know, if the owners don't have potentially the knowledge and the base, does that create a higher risk for the firm to have deficiencies in its system of quality control or potential to issue financial statements in conformance with professional standards?
Thank you for that. I believe we had Ms. Corrigan and Ms. Johnson.
Yes, exactly, Mr. Franzella, and very good question, Mr. Dustin. Exactly what I would respond as well. I think it's a risk assessment. You could have partner Jones, and if you look at his bio, he's really tax, and that's his specialty. But by the way, he's got some compilations, reviews, maybe an audit, whatever. He signs a report. So a peer reviewer might use that in risk assessment and say, you know, maybe I better look at a little bit more under, you know, his area of practice and make sure that these financial statements are meeting professional standards. So it's that sort of thing. I'm not sure that anything else beyond that happens. But really important was to make sure the client knows, you know, who is responsible for the financial statements.
Thank you, Ms. Johnson.
Thank you, and I apologize for all of the questions, but as people are speaking, questions start formulating in my mind. One of the other risk assessments that I've thought of during this last discussion was if the partners don't are not responsible for signing off on the attestation engagement themselves, and one of their staff, or I've worked in enough companies to know, is there proper oversight by that staff person who's actually signing that engagement? Is that person, is there any pressure on that person from their bosses to sign that engagement when realistically they're just signing it because they have the credentials to sign it, not that they have the ability to push back or perform the proper oversight for to take on that responsibility, and the pressure could be, you know, just to save their job. Those types of things that I'm experienced enough to know that does happen with lower level employees. If the owner is not taking the responsibility and the employee is, what level of risk is that employee taking on themselves?
Thank you for that question. I think you're highlighting one of the consumer risk concerns with the situation that we have, and we've spent quite a bit of time exploring lots of questions, some history, some background. We've had great information, I think, from the staff and from the contributions from the committee. This may be a little linear. But one of the things our group is supposed to do is to consider 3 specific questions. So I think I'd like to ask the committee, after reflecting upon these conversations, one of that first questions is, what is the problem the Board of Accountancy is attempting to solve? So for me, I believe those are the 2 procedural questions raised in item 6, and I would call them, in my own shorthand descriptions, there was a very lengthy description, but non-A license firms and concerns with conversion licenses. Are there other problems this board is attempting to solve here today? I'm happy to open the floor and hear how you're formulating this conversation into answers for that question. What I might just throw a question out there is, I guess I'm curious is maybe some of the history or some of the statistics we've maybe asked for to come back later might shed light on, but we might actually be digging into some disciplinary process issues. But so we'll move on. We have those 2 main problems I believe we're trying to solve. The question is, who will be impacted and how will they be impacted? Mr. Simidian?
I'm sorry, my comment didn't relate to your most recent question. If I can you just go back, just get a point of clarification. It was something Mr. Frenzel was talking about. Just so I'm clear, the requirements to be licensed as a firm do not have the same distinctions that an individual would go through in getting their certification. In other words, there wouldn't be an attest license for the firm versus a general license for the firm. It's just the individuals who are the principals or the partners or the owners of that firm that determine that. Like, could there be a firm that's like an A firm that is licensed to attest, and then there's a firm that's not? Or is it more to determine based on the owners of the individuals that own that firm?
Mr. Franzella?
Thank you. So, no, a firm is just issued a license. So it doesn't have an A designation or a G designation to it. It's just the license. The limitations of the firm are, there's potential limitations, but there's not any direct limitations. So if like in the scenario we've been discussing, if a firm gets its license and the owners are all G, in theory, at least none of the owners can sign attest reports. But if they have employees who have met the attest experience requirement, then that firm can't issue the attest engagement. It can be signed by one of those employees. So there's no inherent limitations to the firm itself.
May I make a follow-up question?
Certainly.
So can we ask staff, and maybe this is more directed to the chair, to staff to, and maybe you know this already, whether there is such a requirement in other jurisdictions that through the licensing process, that the firm demonstrate in some way that they have the requisite skills or experience among its partners to perform these attest functions?
I'm wondering if that question would only be specific to the jurisdictions that have attest requirements. I don't know. Mr. Franzella, thoughts?
So yes, it would probably be more specific to some of those states, like Iowa, and the jurisdiction of Guam, because we're the only other states that have that. Many states that I'm aware of, they require firms a lot of firms can practice without being licensed. The trigger is actually the attestation service. So some states only require firms who perform attest level services to become licensed. I think the issue that we would run into in those particular areas, and we can definitely do the exploration just to ensure it, is those states don't have a attest experience requirement. So the owners are, I don't want to say that they don't have that experience, but they're issued under the G kind of banner like we have. So there's not going to be this inherent kind of understanding. Those firms probably are having to be enrolled in peer review and stay enrolled in the peer review program in those states to continue to keep their A license. But I don't think there might be anything beyond that. I don't know if Mr. Dustin knows, but we can definitely look at it, but I think it'll have limited probative value only because the states don't have an attest experience requirement as that backstop.
Ms. Johnson?
And I think this question was already asked maybe by Ms. Corrigan, but the more our discussion goes on, it would be very interesting to learn what are the controls that are in place from the states that do not have the attest requirement. I think that would be very helpful in us weighing this decision. Also because of members of other states may still be performing attestation engagements here in the state of California. So realistically, where we may be prohibiting or putting additional obstacles in the way of firms here in the state of California performing attestation engagements, other states who do not have that attestation requirement may be performing services for the public here in California.
Thank you, Mr. Franzella.
So just a quick type response to that. The board, for a better part of a few years, went through what was called substantial
Equivalency?
It's equivalency, but it's not from the mobility perspective as it relates to the licensure requirements, but it did a substantial equivalency test of the states from a mobility perspective for enforcement, and looked at working with NASBA over the course of, I want to say, and Ms. Salazar was on the mobility stakeholder group that looked at this for several years, to determine whether or not states had minimum disciplinary structures or guidelines to help provide a level of confidence that those individuals who might be operating in those states, when they came to operate here, could be effectively monitored, disciplined by those states, while at the same time California could still impose its own discipline, that those states have those checks and balances in place. And so the board did look at states, a fairly comprehensive review, and when I say fairly comprehensive, a very comprehensive review of states' equivalency to guidelines nationally that NASBA had developed. And we even compared California to those guidelines to make sure we were meeting those expectations. So there has been some of that dialogue. Obviously, one of the things we can do is we can try to resurrect some of that information as it relates to that comparative analysis for how states manage their risk as it relates to the attest experience requirement. But the board and NASBA did quite a bit of work on that with the mobility stakeholder group.
And thank you for that. And I'll just throw in a comment as well to Ms. Johnson. What I learned out of that process, and it did go on for several years, and it was pretty exhaustive, was that states do it very differently. And in fact, it feels like nobody does it quite like California. We are structured and resourced very differently than the majority of the boards out there. And so it might be relevant to maybe pull some of the more consistent size jurisdictions to see how their processes work. But I think the outcome of that particular analysis might not necessarily yield quite the detail that you're looking for, because their systems are so different. It actually took NASBA to sort of bridge that process of understanding each jurisdiction's system and how it is equivalent to California's. And we arrived at that determination, but it might, as across 55 jurisdictions, not be as helpful, possibly, as we might wish. So my recollection is, again, they are consistent. They have different structures, but they're consistent to what we do today. So again, I think our perspective probably needs to turn inward about what our board needs to do for its backstops and its to protect its consumers, unfortunately. But I love the question, and I appreciate the staff making note of bringing some of those substantial equivalency conversations back to us, because I think that is really, really relevant to what we're talking about. We had a question of what is the problem we're attempting to solve, and this is a question maybe for staff. This conversation is, do we have a concern with our current structure with an inconsistency between individual and firm licensing, in that they're not necessarily parallel and that could potentially confuse consumers? Is that a question, or is that me reading too much into all of this detail? Mr. Franzella?
Obviously, we have some policy issues that we've outlined that have some concerns. I wouldn't say it's an inconsistency. When they developed the A and G license experience requirements, it didn't follow through to the firms in as much as whether or not they should also have an A or a G, and they should only be issued A or G if they have ownership that matches. The board has considered that topic and obviously took a different path back then related to client notification and information to keep consumers informed of whether or not a firm has the capability to, or personnel to perform the work. I will say it also came up during peer review because peer review is a firm requirement and we don't register the sole proprietors that are unincorporated sole proprietors. And I want to say we did some work back then on trying to guesstimate what it was, and we were pretty close, at least in terms of its final volume of peer review. I think we had roughly 6,000 licensed at that time. This was 11 years ago, 6,000 or 7,000 licensed accounting firms, and about that many or close to that many who are unregistered sole proprietors. So there was also discussion about requiring firms who were doing a test level work, sole proprietors who are doing test level work, to sign up so we can know who had to go through peer review. So there have been prior discussions on it. So it's, again, this task force can definitely look at that and see if that could be something that wants to be discussed, or would it also, or just better safeguards in place to inform consumers so we don't create an extra layer of licensure distinguishing the difference between an A and a G firm on top of the A and the G license.
So I'm going to process all of that in the context of this discussion. And to me, that really refocuses us back on the primary questions are just the two that are presented, the non-A licensed firms and the conversion licenses. And then those are really the two primary ones. But we have Ms. Hines' hand up.
We've been going for a couple hours now. I'm wondering when we're going to take a break and what's our timing plans.
Thank you very much for that question. We can go ahead. I will look for nodding heads, but it might be appropriate to take a 5-minute bio break. I feel like at this point, we are nearing sort of finalizing our questions and then wanting to move into the next area, which is going to set out some action items. So I don't presume, I'm hoping that it won't go too long, but would our committee enjoy a bio break for 5 minutes? Am I seeing any nods? Okay, I've got a few thumbs up. So it is 11:42. We're kind of pausing with the question of who will be impacted, how will they be impacted, and then we'll move forward to kind of wrapping up this section and moving into questions. We have Ms. Bowers before we break.
Hi, thank you, Ms. Salazar. If we anticipate we're going to go through the afternoon, if we could make this a 15-minute break, I would appreciate it.
When you say afternoon, do we have staff that have a hard stop at noon?
No, just we're required to provide staff a 15-minute break in the morning. So if we're going to go past the noon hour, then we would need to extend that 5-minute to 15.
So I'm going to make a guess that it would be lovely to be done by 12:30. Is that consistent with our initial scheduling for this meeting, Patty? I want to be respectful of everyone's time. Patty? You're muted.
I'm so sorry. Yes, but if we're going to go past the 12 o'clock noon hour, we need to break for 15 minutes for, it's a requirement.
Certainly, understood. So my suggestion at this point is we've had a lot of significant comments and questions. Let's go ahead and take a 15-minute bio break. We will come back at noon. I am hoping to convene at approximately 12:30 or so, just to give people a scope. But I think we're moving quickly towards the sort of definition of asks and questions. So with that, I'm going to go ahead and break the meeting, and we will return exactly at noon, which gives you 16 minutes. Thank you. We are just concluding the break for the consideration of CPA Experiences Requirement Task Force, or Cert meeting and are holding for a few folks to rejoin. At this point, we're waiting for just 2 members, I believe. Is that correct? Do we have them on another screen where I can't see them? All right. Now we are waiting for 1 member to return, I believe. So we do have a quorum, so I'm going to watch our executive officer for her to nod, but I believe with a quorum we can go ahead and proceed. Is that correct?
That's correct.
Fantastic. All right. Well, our final member, I'm sure, will be joining us momentarily, but I'd like to reconvene the meeting. We are working on item 6 and have had a robust discussion that explored a lot of the complex issues around this conversation in terms of necessary and sufficient. The next steps really are, if you read in materials, are based on the directions from this committee. Staff will perform research and begin evaluating how recommendations may impact the CBA, its stakeholders, and provide timelines. So with this point, during the break, I was able to coordinate with the staff. And so the good news is we have multiple staff members taking copious notes during all of these discussions. So we will not need to recap, thankfully, all of the primary questions that have been raised. Staff will actually coordinate and distill that down and then work with myself as chair to bring some additional agenda items back to the next meeting. So at this point, I believe our conversation is sufficient to meet the requirement for staff to move forward with providing research and additional information. But I do want to, after this break, be sure to open it up to members one more time in case anybody had one last question or comment that they wanted to put in to this discussion. And then after that, we will open for public comments. We have Ms. Hines.
Yeah, I had a note to myself, and I'm sorry, it's not complete, but I had a note to myself about let me find it, about the public company accounting oversight board, oversight over audits that are performed regarding publicly held companies. And I wondered whether there is any connection between what that board does and our attestation, requirement and the experiences that we may have regarding companies or, licensees that get sanctioned or get, have, experiences with that PCAOB board. I haven't fully formulated what the issue is, but I wanted to raise whether there's any connection between the, responsibilities and oversight of that board and what we are looking to do with requiring the attestation experience. It's a very open-ended, statement that I'm making, comment that I'm making.
And it also might just be a little bit of education about how the referrals and the compare and contrast, and see how maybe our board works with that agency. And I can think of maybe the Department of Labor also has some oversight for audits. Is that maybe what you're looking for?
Yeah. I mean, as staff is researching the issues that have been raised today, keeping in mind that oversight body as well, and whether there's any, connections to what they do, or issues that they may, find, and what we're trying to accomplish here with this task force.
Right. All right. Well, thank you for that. I'm not seeing any other member hands up. Sorry, at some point I muted myself. So I'm not seeing any other member hands up at this point in time, but I would like to invite the public for comment at this point. So if I could ask our moderator to please open for public comment, that would be appreciated.
Thank you, Madam Chair. I've opened up the Q&A panel. If any member of the public would like to make a comment on agenda item 6, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists. Or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I'm not seeing requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
All right, thank you, moderator. All right, so with that, we get to move along to agenda item 7, which is discussion and possible action to approve meeting dates for consideration of the Cert issues. So Chief Franzella, would you like to begin your presentation?
Thank you. So item 7, as Ms. Salazar had noted, is to approve a calendar for future meeting dates for the Cert group. And so on page 2 of your material, staff have highlighted dates through the remainder of this calendar year. And our 3 of the dates we are proposing align with the board meeting themselves, which would be in May, September, and November. We did identify that there was a conflict with the National Association of State Board of Accountancy meeting to potentially have them all align with the board meeting. So for the July meeting, we're listing out a handful of dates and various times for the Cert's consideration. As members consider the future meeting, as was talked about early on, I think actually right before the meeting started, the executive order that allows us to conduct meetings in the virtual setting that we do today expires, I believe, on Friday or at the end of the month. And so future meetings, unless either a new executive order is issued or some legislation is passed in the interim, will necessitate at least a physical location for future meetings. And if they are conducted in person, members will have the option to participate via teleconference. However, these would be under the conditions that their location is accessible to the public, disclosed on the meeting agenda, and is compliant with the Americans with Disabilities Act. So with that, I would like to turn discussion over to the chair and members to approve a calendar, again, with the approval being at least for those May, September, and November dates, and then selecting one of the optioned meeting dates and times for July.
Thank you, Mr. Franzella. I guess to make it simple, I'd like to ask the committee to consider the May, September, and November dates first to see if those work. So I guess I would like to ask if we have any concerns or conflicts with the CBA aligned meeting dates as presented for those 3 meetings. Everybody loves it. I can see that. There's no hands going up. So wait, Ms. Hines.
Sorry, I just, the November 17th meeting, I have a conflict. I have a conflict with the Board of Accountancy meeting as well. So I just so raised that.
Okay. Can we agree on May and September? Okay, so it sounds like we're good for May and September. We have one potential conflict, or we have a conflict. It's not a potential conflict. We have a conflict on November 17th. We would still have a quorum, it sounds like. So maybe put a pin in that and we can revisit it. But we do have an issue with July where we are being presented with 6 different dates. Mr. Franzella's hand is up, and Nancy Corrigan.
Sorry, my hand was not intended to be up. I was just clicking my pen.
Yes, Ms. Salazar, I am not available for Wednesday, July 13th or Thursday, July 14th of those July dates. The other dates work fine for me.
Thank you. And you read my mind with what I wanted to do was ask for dates that do not work for our members. Ms. Hines, are there any July dates that do not work?
July 12th and July 26th, I am not available.
How is the committee feeling about the 27th and 28th? Those look like we possibly do not have conflicts on either of those. Mr. Simidian?
You're on mute, Mr. Simidian.
My apologies. I'm not available that week of the 26th.
So with that, we have no good dates for everybody. Can I direct staff to do a doodle poll for that meeting for the November and the July meetings? Would that be appropriate? I've lost Patty from my screen.
Yes, we can do a follow-up with the members.
Okay, I think that might make sense. It sounds like though May and September are dates that are good for our committee. So the good news is we are good on those, and then we will have to coordinate. And then as staff need, maybe they can reach out and refine their limitations if they need to talk with staff about conflicts that they have on particular dates. And hopefully staff will, of course, be keeping us apprised of any legislative changes with virtual versus live meetings, as I'm sure that might impact some people's availability as well, because adding travel does make meetings a lot tougher to schedule. So we have been asked to adopt or modify the proposed dates. It seems that we are prepared to adopt May and September. Do we need a vote, Patty, at the committee level for that, or can we table it until?
Either way, you can table it if you'd like, and then we can just follow up at the next meeting with a firm calendar. That would work.
So the one thing we will do is we are at this point in agreement about our next meeting date, which will be held aligned with the California Board of Accountancy meeting on May 19th, with our location to be determined based upon where we are with virtual versus in-person meeting guidance at that point in time. Are there any last-minute member comments on this agenda item? And I believe, seeing none, we are still also required to open it up for public comment as well. Moderator, would you be willing to do that?
Thank you, Madam Chair. I've opened up the Q&A panel, and if any member of the public would like to comment on agenda item 7, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. We will give you a moment. All right, I see no request for comment at this time. Shall I close the Q&A panel?
Yes, please. And there was a hand raised that I just did not see in time from Ms. Hines. Do you still have a comment on that?
I do. I just was slow in raising my hand on the screen. How much time would we need for this meeting if it's going to be? I'm just trying to get an idea of how this aligns with the CBA meetings. So, if we were meeting in person, would this task force meet, and say like the morning, or like how's the task force going to operate in conjunction with the CBA meetings?
So as chair, I'm going to let Patty handle that because I see your hand is up. So thank you, Patty.
Thank you. So I wouldn't be able to give an exact answer today because what we'll do is we will look at the agenda for the May board meeting. We'll need to look at whether we have any petitioners, so we'll have to have an ALJ present, what other agenda items, what other committees are meeting, and then we will come up with a schedule. But typically our committees meet on Thursday in the morning, then we move into CBA meeting in the afternoon, and then Friday is the CBA meeting. But again, we sometimes have to adjust that just based on scheduled items. And so we'll have to get back to members once we have a better idea of not only how much time we'll need for this task force to meet next time, but also the time schedule for the other committees as well.
I'm sorry, as a follow-up, I just want to get an idea whether, we will definitely be able to meet that day, or whether there's a possibility we may be asked to meet, either, the day before or the day after, just to hold the calendar, and keep in mind for planning purposes.
Yeah. The goal would be to have this task force meet along with the board committee meetings, which typically is Thursday, but that could change once we see whether or not we have petitioners and whether or not we have to have an ALJ present. Sometimes they're not available on Fridays, so that dictates our schedule. So I wouldn't be able to give a firm response today, but I would say more likely than not, it would be on a Thursday for this task force.
Thank you.
Okay. All right. Well, thank you for that. So we've had member comments, we've had public comments. I believe that closes out our agenda item number 7. And I appreciate the committee's patience with this meeting. I think this gives a lot of direction to the staff in terms of what they can bring in, and they'll be able to bring us materials back that will really help inform our next conversation, and we'll have a little bit more direction than the exploration here. We're moving on to agenda item number 8. This is for items for our next meeting. And so in addition to the staff's work, which will be bringing questions back to me as chair to help craft an agenda, is there anything additional that you would like to have added as a future topic? Please raise your hands. Right. So I'm not seeing any committee requests for additional items at this point. So thank you for that. And we also have an obligation to open the discussion to the public. So if I could ask our moderator to please open the public comment panel in case there are any contributions from our listeners.
Thank you, Madam Chair. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 8, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may raise your hand. We will give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel? All right, I'll close the Q&A panel.
Sorry, thank you. I think I was muted when I said that. Thank you for closing it. All right, so with that actually concludes our agenda. I want to thank all of our committee members for joining us. I know this meeting was long, but I appreciate the questions and the input and look forward to working with staff to bring you back materials and an agenda item for our next meeting, which will be in May. Thank you so much and be safe. And this meeting is adjourned at Pacific time, 12:19. Thank you.